What to do if your application for temporary residence permit to Ukraine is rejected, or a previously issued temporary residence permit was cancelled? My name is Ivan Goncharov. I'm an immigration lawyer. It's important to note that the current legislation of Ukraine does not provide a full list of reasons for cancelling or rejecting in issuing a residence permit for foreign citizens. However, in this video I will tell you about most widespread reasons for such situations. The Immigration Service of Ukraine can reject to issue a temporary residence permit if a foreigner violates the term of legal stay in the territory of Ukraine, means that he or she has overstayed the visa or visa-free regime. Or in case if a foreigner received a deportation decision previously but yet didn't leave the territory of Ukraine. Or in case if there is an entry ban decision pending on the foreigner. Or in case if Migration Service employees will find out that there are mistakes in the state registers from other authorities. Or in case if a foreigner applies for residence permit with violation of 15 working days prior expiration of his legal stay in the territory of Ukraine. Or if a foreigner submitted incomplete documents for the temporary residence permit. Or in case if the Migration Service receive information from National Police or State Security Service about threat of a foreigner to the security of Ukraine or public order. And the most widespread reason that a foreigner submitted forged documents or false information. Also, a foreigner can be rejected with a residence permit if he or she has debts, unpaid penalties, alimony, etc. However, as I've mentioned previously, the current legislation of Ukraine does not contain a full list of reasons for such situations. It means that a foreigner can face rejection in other circumstances. As for decision to cancel previously issued temporary residence permit, the reasons almost similar as previously. For example, if a foreigner obtained a temporary residence permit, however, after some time the Migration Service did some extra check and found out that there was submitted forged documents or false information, they can cancel such a temporary residence permit. Or subsequently, if the Migration Service will receive information from law enforcement agencies about threat to the national security or public order. A temporary residence permit can be also cancelled upon a motivated application from the inviting party. For example, if it's employer, university, or non-governmental organization. Also, if a foreigner will commit a criminal offense for such a reason, the temporary residence permit will be cancelled. So, what to do if the temporary residence permit was rejected or cancelled? First of all, a foreigner should receive an official letter from the Migration Service and read it carefully. Most likely that the foreigner will need to get extra information and official documents to understand the real reasons and its details. In case of rejecting or cancelling a temporary residence permit, a foreigner will have only 1 month to appeal such a decision. Otherwise, a foreigner should leave the territory of Ukraine as soon as possible or will face deportation. If a foreigner will decide to leave the territory of Ukraine, he will have only 7 days to do that. It's important to note that the period of appealing the temporary residence permit rejection or cancellation will start from the day when a foreigner received an official letter from the Migration Service and put his or her signature. While a decision about rejecting and issuing a temporary residence permit can be appealed out of court and through the court, the decision about the cancellation of the previously issued temporary residence permit can be appealed only to the court. Another important information that in case of appealing any of such decisions, a foreigner will be legally staying in the territory of Ukraine until the final decision of the authority or the judge. Why need an immigration lawyer for such cases? Apart from comprehensive legal consultations based on a proper assessment of the case circumstances, a lawyer can send requests to state authorities to collect extra information and document copies. Also, a lawyer can represent interest of a foreigner out of court and in court. A lawyer can provide appropriate motivation to maximize the chances of the appeal. Entrust your cases only to narrow-profile specialists, lawyers who specialize in specific issues. Thank you for your attention.